You know,
Jackie Oyuyo Githinji
Yes.
is our guest in the studio this morning. So we didn't have our justice conversation yesterday, Justice Thursdays. We're having it today. And we've been talking about alternative means of resolving disputes. One of them is arbitration. And Jackie is the chairperson of the Nairobi Center for International Arbitration. Good morning, Jackie.
Good morning.
How are you?
I'm well.
Are you well fed?
I'm
By
well
self
fed.
or otherwise?
Literally.
Okay. Good to have you in the show.
Thank you.
Karibu sana.
Asante.
The Center for International Arbitration. You know, those are the people who call themselves chartered arbitrator or arbiter. What is it?
So there's you can qualify to become a chartered arbitrator through a process, which can take several years. Most of us who have that title, and I'm one of 3 Kenyan women who have that title, are members of the Chartered Institute of Arbitrators. Where does our charter come from? From the Chartered Institute in the UK. So you start your membership at associate level. You do an entry course, which is open to all professions. It's not, there's a misconception that arbitration is the preserve of lawyers, which is incorrect. Actually, when I started studying arbitration, we had a lot of engineers, quantity surveyors, architects, basically the built environment. We even had a pilot in my class, basically people from different professions. In fact, I wonder why we don't have more journalists in the profession, because we could certainly use a different skill set in the profession. So anyway, you start as an associate once you do your entry course, and then it's a modular learning. So with different modules, you qualify at different levels. You become a member and then a fellow. And then finally, you do what is called a peer interview, and based on your experience and the types of decisions you've made in the past, if you're considered a safe pair of hands, then you achieve then the chartered arbitrator status.
What is arbitration?
All right. So I can't talk about arbitration without talking generally about dispute resolution mechanisms that are alternative to the court system. And the only reason we talk about alternative is because we have been cultured, at least since independence, to resolve our disputes in court. So anything that is outside of the court then is considered alternative to the court system. And there's a spectrum of dispute resolution mechanisms, starting from negotiation, which is somewhat informal. We could sit around this table and just negotiate our way out of a dispute as parties. Or we could then bring in a third party, which is where some of the dispute resolution mechanisms that you've become familiar with come into play. So, for example, you could bring in a mediator, who is a third party that doesn't resolve your dispute, but facilitates your negotiation. So maybe you have both, if you're 2 parties, you have both, stood very firm on your different positions. The mediator comes to help you unpack those positions into what the underlying issues are and help you to resolve your dispute, not by giving you a solution, but generating ideas and helping you to come to a solution together. This is somewhat often confused with conciliation, which is typical in employment disputes and is actually provided for in our employment and labor statutes in Kenya. Conciliation, the difference with mediation, which I've just described, is that the parties may ask the conciliator to draft a solution for them to consider, which a mediator will never do. And then if you move higher up the spectrum, you're simply moving away from informality and sort of party autonomy to a more structured system, which is where arbitration comes in, and then finally litigation. And if nothing else fails, then we see outright war. So arbitration then is the more formal process, a step down from litigation, if you will, to the extent that you have invited a third party, who is the arbitrator, who has come in to then give you a decision based on what you have shared with the arbitrator. So it is a little more formal than the other processes that I described. In Kenya, we also have an alternative justice system, which considers our traditional dispute resolution mechanisms to the extent of, obviously, that, as described in the Constitution, those mechanisms are not repugnant to morality or to our value system as Kenyans. Yeah.
Is arbitration then given as an option when something else has failed, or can it be a direct selection from the very beginning of whatever dispute that you're handling?
So it really depends on what the parties decide. And a lot of times in dispute resolution clauses, which we call them the midnight clauses because people draft them after they've fought over everything else. And then this is the final clause we're drafting. So sometimes a lot of care is not taken in those dispute resolution clauses. However, they may have what we call a graduated system. So start with negotiation. If it fails, go to mediation. If it fails, go to arbitration. So to that extent, the parties can select it directly. You could just do away with all that and say, if we have a dispute, we're going directly to arbitration. Or you could have this more graduated system. It really depends on the parties.
And who's using arbitration services? Is it government? Is it big businesses? Is it employers with their staff?
Okay. Yeah. So let me answer that question in the context then of the Nairobi Center for International Arbitration. What we have seen is that a lot of contracts arise from the commercial space. And that space then is really everybody, if you think about it, because you could have a simple contract for the purchase of a car, or you could have a complex infrastructure project such as the expressway we have a clear view of here. So to that extent, then a state can be party to a dispute based on a bilateral investment treaty. Or it could be even in the family space, which spills over then into a dispute. It could be an employment dispute. It could be a mining dispute. It could be a contract for the supply of goods. So a very wide array, which simply means that arbitration is available to a broad section of our society.
And who is using it? If you look at
currently,
right
the bulk of our at the center, every year we publish what we call a case report, and it's available on our website. And our year, starts July to June. So the previous one, which is for the period July 2020 to June 2021, the bulk of our disputes were arising from supplies of goods and services. And then we had some, in equal portion, then employment disputes and disputes arising from construction. So at the center, for the last financial year, we saw mostly domestic disputes, I would say. And domestic just means the parties are Kenyan and the dispute is then, resolved in Kenya. And like I said, largely from the supply of goods and services.
To government or across the board, or you didn't analyze to that level?
Across the board. Across the board.
Interesting.
Yeah. How binding are the resolutions that you arrive at?
As an arbitrator, what you issue is called an award, and the award is final. Now, what has tended to happen is that, and the reason it's final, CT, is because the parties elected arbitration as a dispute resolution mechanism. Now, what has tended to happen is that if one party is not happy with the decision, they will then challenge the award. And some people have started to call that an appeal, but in the strictest sense, it is not an appeal. It is simply a challenge to the decision, and based on very clear criteria that are set out in the Arbitration Act of 1995. And the grounds for challenging an award are quite serious, to the extent that it borders on the conduct of the arbitrator. Was the arbitrator impartial? Was the arbitrator biased? Did the arbitrator actually take a bribe? Did the arbitrator give both parties or all parties a fair opportunity to be heard? Was there due process? So those kind of things are the basis on which you challenge an award. So it's not simply that I'm not happy with the decision that the arbitrator gave, but there are serious grounds of misconduct or fraud in the process.
Okay. Let me give you an example.
Yes.
Two people are engaged in a project. And the contract details stipulate that in the event of a disagreement, they go to arbitration. Now, who decides who the arbitrator is? And if there is a disagreement as to who the arbitrator is, how long can this matter be prolonged before it is actually determined?
Okay, thank you for the question. So who decides? The parties decide, because remember we said it's a party autonomous process, which means the parties decide who the arbitrator will be and, which institution, for example, will administer the dispute, and I'll talk about that later. The parties can say they can define a person or they can define a skill set. So they can say, I want somebody who has 10 years experience in journalism, who is of a specific gender even, or from a specific country because of the perception of neutrality. If one party is from one country and another party is from a different country, they will state what criteria they want, or they will state we want this individual, or we'll select from these 3 individuals who both parties have nominated, and then we consider which of them is best suited to hear and determine the dispute. So it's up to the parties.
And if the parties can't agree, and
that happens. So this is where centers like the Nairobi Center come in, because if your dispute resolution clause is well drafted, then you will have indicated in the event of failure, of appointing failure, then we want a specific institute to appoint an arbitrator. And appointment means you leave it in the hands of that institution. You don't come back and start to challenge in perpetuity, like you're saying, because the idea is to have a process that is then efficient and is not, riddled with the usual delays. You simply want to have finality, even to the appointment of the arbitrator. And that doesn't mean that one party will not subsequently challenge. It's quite common for the appointment of an arbitrator to be challenged. And at the center, we then have a process through which we've established a structure called the arbitral court. And that arbitral court, contrary to its naming, is not determining disputes. It is determining issues such as the challenge of the appointment of an arbitrator or the challenge of the award.
Do these processes have an expiry date, or they can move from one generation to the other ad infinitum?
Again, depending on the parties. And, for me as an arbitrator, it's very disappointing when parties come to a process and then we're arguing for 5 months they're arguing for 5 months about the appointment of the arbitrator, or they're arguing about a timetable. So one of the things you do almost immediately, you start the process, you invite the parties to a preliminary meeting, and you sort of set the tone and pace for the arbitration. So you'll have a schedule. This is when the claimant should file. This is when the respondent should file. But, life happens, delays happen. So as the arbitrator, you are then looked at as the master of procedure. You have to then start to push in a certain direction without compromising fairness to both parties. So it's a delicate balance of efficiency in terms of time and cost, and always reminding the parties that really it is up to them to make sure that the process is as efficient as possible. And if they're represented by lawyers, then also imposing on the lawyers those kind of requirements as to avoiding delay and avoiding unnecessary expense, because ultimately then it becomes costly to keep delaying the process.
In the event that there is a challenge to an award, to whom then is the challenge presented? Who handles the challenge?
So in Kenya, the High Court.
Okay.
Yes.
All right. So then essentially it could then end up in litigation, which is what you are trying to avoid in the first place.
Yes.
So how often do these happen? When there's an award and then there's challenge to the award, how often do we see these then going back to the High Court? And then in addition to that, what kind of cases, I know you may not be able to speak to the matter of, but what kind of cases are we seeing that end up in arbitration in Kenya?
So generally, I'll answer the last question first. We're seeing cases around supply of goods. And goods, of a very broad range. Whether it's in the manufacturing sector, whether it's a commercial sector, whatever it is. And also in construction, infrastructure, or even, say, gated communities, apartments, whatever, those kind of disputes as well. And the percentage, I would say, and it's not empirical, just a gut sense, is about maybe 2% end up in court. And what then happens is you start in High Court, and maybe the High Court takes a certain position. Now, because your lawyer has told you that there's still a chance.
Ground iko na wewe.
You then end up in the Court of Appeal and then the Supreme Court. And it has happened. And to some extent, there are some that needed to end up in the Supreme Court to bring finality in terms of saying this is the extent to which courts can intervene. And it's very clear, even in the Arbitration Act, the extent to which courts can intervene. The role of the court is quite limited. And it's limited to circumstances such as the one Citi mentioned around challenging the appointment of an arbitrator. You can go to court to challenge, but also around the award itself. So the court, and thankfully in Kenya, because of our constitution, we have a court that is respectful of alternative dispute resolution mechanisms. And in fact, if you go to court, say you and Eric have a contract and you have a dispute resolution clause that encourages arbitration or actually requires arbitration, and you go to court, the court will send you back to arbitration.
Oh, right.
Yes.
Because they'll be able to see that.
Yes.
Follow process. Before you
Yes.
get here, you had said
Yes.
that you were going to arbitration.
Okay,
Correct.
what are you doing here?
You've
What's
mentioned the Arbitration Act, Jackie.
Yes.
So you're already anchored in law. How many institutions does this act recognize? Yours is the Nairobi Center for International Arbitration. Is it
Yes.
the only one in Kenya?
No, it's not. And actually, the Arbitration Act preceded a lot of institutions, such as ours. Ours is about, 9 years old? Because the statute is 2013. And of course, the Chartered Institute is a lot older, but is a global institute. So the Act per se does not recognize any institutions. So what we at the center have tried to do, because it's part of our mandate, is then to drive a national policy that governs ADR. To the extent that we are not then introducing unnecessary rigor into processes such as mediation, which require flexibility. But we're saying that if you hold yourself as a mediator, then who has licensed you to be a mediator?
Yeah.
Who is making sure that you are conducting yourself professionally as a mediator? So that national policy, the initial drafting was done through a consultancy under the Nairobi Center, and then the Honorable Attorney General appointed a task force or a steering committee, which was actually chaired by one of your guests who was here a couple of weeks ago, Senior Counsel John Ohaga. And the steering committee then, through stakeholder engagement, which we had also conducted at the center, came up with a draft national policy. That draft policy is simply awaiting cabinet consideration and then parliamentary and Senate consideration so that it becomes policy. And actually, if you think about it, the policy should have preceded any statute. But, we're trying to then clean up and say, we recognize that there's so many forms of alternative dispute resolution, but there is no sort of structure in terms of professionals, professional conduct, even in terms of the understanding of these dispute resolution mechanisms and therefore the uptake. I know you as a team, you're also familiar with the court annexed mediation, which
That's
has
the word I was looking for.
which has taken
Court
root.
annexed. Yes.
Which has taken root. It started off by being piloted here in Nairobi, and then it has been rolled out to, I think, by my last count, about 15 counties. And really just to dispense justice to a wider audience and in a way that is perhaps, in our traditional sense, more familiar to us.
Before we take a break, so let me ask then. There is the Arbitration Act.
Yes.
Does it encompass everything? All the things that you've talked about, negotiation, conciliation, mediation, arbitration. Is everything under the Arbitration Act?
No, and hence the national policy, which is then proposing a dispute resolution bill, which will encompass...
Which will now have everyone.
Yes, and if necessary, make amendments to the Arbitration Act that would be necessitated by the policy.
Let's take a break. It's 28 minutes to 8, Kenya's biggest conversation. Eric Ndu City, Constant. Guest host, Wanjiru Gekonyo. Host this hour, Jackie Oyuyo Githinji. She's the chairperson of the Nairobi Center for International Arbitration, talking about how arbitration works as a dispute resolution mechanism. Good morning.
This is the Situation Room, the only way to start your day.
Wanjiru, you had a question before the break.
Yes, the question I had was about cost and time. Obviously, you don't want to go through the court process. Court cases can drag on and on. What's the cost benefit? What's the time benefit? And where's the oversight?
Okay. So,
So,
So, deep
when someone is
Yeah,
talking
yeah,
about
you know
money
when
and
I
they tell you
say,
so,
I'm about to say it depends.
Yeah, like no difference at all.
No, and I will be honest and say that there are sections of the consuming public who believe that arbitration is becoming more costly than the court process. You know, in court you have your filing fees, and then maybe have your legal fees, and you have sort of very definitive registry fees and that sort of thing. Now with arbitration, the costs you're looking at are, firstly, if it's an administered dispute, and I had said I'd speak about this at some point. Administration of a dispute simply means that you have a secretariat, such as the NCIA, that is, handling the dispute resolution process from the back end. So
it's
they're
like the
not-
registry.
Yes, so they're not the decider, which is the arbitrator, but they're helping to communicate and all those things. And we then also incorporate our rules into the process. Now, generally, institutional rules are intended to fast track or to hasten the process. In fact, when we amended our rules in 2019, it was also to introduce what we call expedited arbitration or emergency arbitration, which if it's something you want done quickly, then it's important that you adhere to certain timelines. So almost all institutional rules, if not all, will give a timeline for certain things to happen, when a statement has to be filed, when the decision has to be made, that sort of thing. Costs really are usually a factor of the amount in dispute. So if, for example, at the center, we have a tiered system where at a minimum everybody will pay a fee of I think it's $1,000, $100,000 essentially, at the lower end of the spectrum, and this will increase depending on the amount of the in dispute. Now, if you have a tribunal that comprises more than one arbitrator, then you're looking at fees 3 times over. If you have a dispute that involves several parties, then obviously there'll be more time taken because different parties have to be given the opportunity to be heard. If you have parties who are, in different jurisdictions, then of course time comes in. You have a party in San Francisco, you have a party in Japan, a party in Kenya. What is the most efficient time to meet? And thankfully, the pandemic has taught us that we don't have to meet physically. So we've introduced virtual processes. Even at the center, we've introduced a virtual process. And that comes with its own challenges and also opportunities. In addition to that, there'll be costs still, if you're represented, your legal fees. Now, by our last estimate, the bulk of the costs were arising from your representation. The rest of the costs, say 26%, were arising from this administration of the process and from the registry process and from any other processes that are necessary. For example, you want to bring in an expert. That expert witness comes at a cost. And so those are the kind of costs you'll be looking at in arbitration. So let me say the simpler, in quotes, the dispute, then the less the costs. The more complex it becomes in terms of parties and in terms of the processes, then it becomes a little more costly.
So it's not so it may be more expensive than a court process.
Yes.
So the benefit then may be the time.
Yes, the benefit is then the time, and to the extent that you remember I had said earlier, you can define the skill that you want in your arbitrator. The more the arbitrator understands the background of the dispute, which is not to say that they understand your particular circumstances, but they're well versed in the sector, then to that extent you're also efficient in terms of the understanding and efficiency from that perspective.
I still don't understand. The when you go through a court process, there's what you pay the courts. But then what you then pay your lawyers. Yes, there's a remuneration order. But beyond that, it's more of an understanding between the lawyer and their client. Now, how then is it really different? Because if you have an arbitration, okay, is it at the point where you're paying that particular secretariat where you're saying the costs may be more? Or is it because at the end of the day, the arbitrator also has to be paid, I'm sure? Or is it the same arrangement you have as when you take a matter to court?
So the legal fees could be similar. because your lawyer may rely on the order that you're referring to. But one aspect of that order, Schedule 5, allows your lawyer to charge based on time and costs or time and complexity. So to that extent, there is that slight risk of sort of additional fees based on your negotiation with your lawyer. In terms of the arbitral process, your lawyer could still use, let me call them the other schedules of the remuneration order to define what fees will look like, which is basically party-to-party costs and then their own costs in terms of representing you. The complexity comes in when it's multiple parties, like I said, and then a tribunal consisting of more than one arbitrator, because then to that extent, the fees are magnified by the number. You could also then say, but who bears the costs? Generally, as with the courts, whoever loses,
It's slapped to the bill.
yes.
There's,
So we call it costs following the event.
there's from my reading may be faulty, but bear with me. Is there a requirement for those who go into arbitration to put down a certain amount of money, whether in escrow or in whatever, prior to the culmination of that particular process?
It's not mandatory. It's what we call security for costs, and it's typically requested by the respondent, where they say this claimant is bringing this claim, but they're not even good for the money if they lose, essentially. So we are asking that they deposit this sum with the tribunal until the matter is determined. And it's, like I said, it's not mandatory. It just depends on the particular circumstances of that dispute and whether one party then requests it.
So my other question was on oversight.
Yes.
Right.
So oversight of...
How do you ensure that the process works, that the arbitrators do what they're supposed to do, they don't go partisan, especially because it sounds like there are various bodies that offer the service. And I ask this because we use public interest litigation, and some of at some point in one of our cases there was the possibility of taking it through arbitration. And I recall a discussion with our lawyers where they were saying, these guys, they're so unreliable. You know, if you get the wrong guy, you're so messed up. We'd rather go to court.
It's the roll of the dice.
Yes.
Is it really a roll of the dice, or is it protecting your turf?
Yes.
The roll of the dice in terms of which arbitrator you get.
Yeah.
And, you know, Wanjiro, it is a genuine concern, and we do have to take a very introspective look as arbitrators and say, look, if the courts were efficient, would people still come to us? What is it that we are offering in terms of value? And it's absolutely important that we must be persons of integrity as arbitrators. And institutions of integrity, for example, with the NCIA. So if NCIA is administering a dispute and a question is raised about the conduct of an arbitrator, what is the recourse of the parties? And this is where, for example, the arbitral court established within our Act comes in to deal with such issues. Parties are still very welcome under the Arbitration Act in Kenya to go to the courts and say, look, this arbitrator misbehaved, misconducted themselves, should not have done this, did not disclose that they knew Eric from high school. And that therefore compromises the decision that they've made. So one of the aspects then of the national policy is then to give this general oversight. Because, as you've rightly said, there are several institutions. What do we know about these institutions? Who is policing the institutions? So if I say I have now certified Ndu to go out and mediate, who is making sure that on a regular basis Ndu is keeping herself up to speed in terms of continuous professional development, is continuing to conduct herself with integrity? And those are some of the issues that we want to address then through the national policy. So we don't want to be, very prescriptive in terms of this is what you should do, but we want to say if you're an institution that's holding yourself out as licensing and continuing to license professionals, then you must make sure that they're conducting themselves in the proper manner. So, much like journalists where you sort of internally manage your conduct, but making sure that if you do cross the line, there is a mechanism for...
There's a media council,
Correct.
which is established in statute, which
Yes.
deals with issues of misconduct in the trade. Do you think, Jackie, we should have some sort of uniformity in your trade? Number one, certification. That certification should be uniform. All accountants will have to sit CASNEB, right? To get that certification to become certified public accountant or whatever level. Should we have the same for arbitration? And number two, should you, as arbitrators, form a professional body like the way we have for engineers, for accountants, for lawyers, for the others? Should you have one? What do you think?
So the short answer is that for arbitration, we do have that sort of body.
Which one?
The Chartered Institute of
Okay.
Arbitrators, which sort of brings us up in the profession and then manages how...
Is it Kenyan or is it international?
It's international. So what we have in Kenya, for example, is a Kenyan branch. So, and I hear you when you say, should we in Kenya have that sort of body? And this is some of the contemplation of the national policy. Inviting stakeholders then to address the question of this body, what should it look like? Who should be at the helm of it? Should it be couched in the NCIA? Is that the proper place? Because the NCIA is governed by statute and is established by statute to sort of drive the ADR agenda in terms of training and education awareness, but also, then bringing in the aspect of professional conduct. For mediation, it's less structured. Yes, the Chartered Institute still brings up mediators in the profession, but we do have other training institutions. By my last count in Kenya, I think we had 5 or 6. We have less structure around that. And like I said, we don't want structure around the process per se, but we want structure around how individuals are licensed, because we're saying you are a safe pair of hands. We can continue to bring disputes to you as a mediator. How do we make sure you conduct yourself professionally? If you're an adjudicator, an expert determiner. So we have these institutions.
How do we trust your
globally.
competence?
How do we?
How do we trust your competence?
Correct.
In terms of, okay, so you're certified. Who certified you?
Yes, and who continues to make sure
And
you
who
stay
continue-
relevant?
Yes.
Yes. So yes, the short answer, yes.
So, I mean, looking at the entirety of the process from what you've been explained, what then would be the benefit overall? I mean, because that's what then folks are weighing. Divergent parties are weighing and say, should we go the mediation way? Should we go the arbitration way? Should we go the litigation way? What would then, from where you sit, be the benefit of going arbitration, save the time aspect that you mentioned?
Okay. So unless you are somebody who thrives in confrontation, chances are you don't want your dispute playing out in the public domain. So one of the benefits of these alternative forms of dispute resolution is privacy. So, unless and until an award is challenged by one of the parties, most people don't know that the process is even going on, unless you're privy. So privacy is a big one. The confidentiality of the process, it's not something that, people will talk about. Unless you have then given them some latitude with the consent of both the other party and the arbitrator or the mediator.
Okay.
And also the whole question of efficiency in terms of time and cost.
Yes.
The due process in terms of fairness, equal opportunity. For example, when you have a mediation in a family dispute, which may manifest as a commercial dispute, we are simply saying we're giving you the opportunity to come and be heard and to say things that you may not be able to say in a courtroom. Like, I wouldn't be able to get to the heart of an issue as a judge, or maybe even as an arbitrator, that I may be able to do as a mediator. Because mediation also gives you the process to say, things are heating up in this room as we're talking. Let's take a moment. Allow me to sit down with Ndu for a minute and just hear her out. And then sit with Wanjiru. And then sit with Eric and sit with Siti and really understand, especially in the family context, it's really important to be able to... because the thing you want to do in an alternative dispute resolution is to preserve your relationship beyond the dispute.
Sure.
And if that is important to you, then these dispute resolution mechanisms really become attractive to you.
And then off the back of that, let's say you've begun in litigation, for example, do you then have people, or do you then have cases sometimes whereby it started in litigation and then perhaps there is the option of then going the arbitration way? Have you found that you can, move levels and then, continue it in that manner when several factors have been considered?
Yes.
Okay.
You can start in litigation and you can say, look, guys, this is not working. It's taking too much time. I'm tired of, this back and forth. Can we try a different way? And if, to the extent that both parties are willing, we have seen success. I'm sure you've seen in the media the reports of family disputes, for example, that have gone on for decades and have finally been resolved through mediation.
Yes.
Yep.
Yes.
Or, parties who said, look, we'll go see you in court because, it's the thing you do when you're upset. But then the reality starts to hit you in terms of how much time and money you're spending. And you're saying, look, let's try a different way. It happens, and it can happen successfully to the satisfaction of both parties. So it's a win-win. And ultimately, I would say, in addition to preserving the relationship, then you also have an outcome that you can live with.
Sure.
Yeah.
All right.
So as we look into, the policy and where the policy is going and the entire profession of arbitration as an alternative dispute resolution, what would you tell anybody who is involved in a dispute? Okay, in fact, no. Before we get to anybody who's involved in a dispute, there's something that you said. When people are, writing down their contracts or striking deals, they just put in there, this contract shall be bound by the laws of Kenya, and in the event of a dispute, it shall be
By the
arbitration.
competent courts, yes.
The arbitration.
Right.
What should we be focusing on at that point of, when we're drafting contracts and agreements, and we'd like, in the event there shall ever be a dispute, to go through arbitration? What should we include at that point in our agreement?
Okay. So when you're drafting a contract, a lot of the clauses you're including in the contract are to prepare for divorce rather than the sustenance of the marriage.
Yeah.
So in the event of divorce, you want to be certainly on a better standing than not be prepared at all. So in a dispute resolution clause, you want clarity more than anything. So you want to be clear on which dispute resolution mechanism you're going to select, how long you're going to give that process of, for example, agreeing the appointment of an arbitrator, like Siti mentioned earlier, or a mediator, which institution you want to administer your dispute, which language you want to have as the language of the process. Are we going to assume it's... Yes, you can get to that level of detail.
English, and someone says, I only understand Chinese.
Exactly. And then you have a dispute around the language, what kind of arbitrator you want, if you want to get that to that level of...
In terms of
yeah.
understanding skill.
Yes.
Okay.
Or even where the arbitrator should come from. And what a lot of Kenyan companies are starting to discover is that they used to put in certain clauses thinking they'd never have to rely on them. So, for example, they'd say, we want our dispute to be administered by the London Centre for International Arbitration. And then it hits you that you're both in Kenya, you're going to have to go to London to administer your dispute. Why? It's going to be really costly. Yeah. So think through these things, and that's why the lawyers are there to help you to think through what makes sense for you, or what will make sense for you in the event that that your dispute, that your contract falls through. What are the kind of things you want? So you want to be clear about the process of dispute resolution, or if it's a graduated process, how long you're giving each process, the neutral, how you want that neutral to be appointed. Is it directly? If that fails, do you want an institution involved? And then if you want to get a little more granular, then you start to talk about things like the language, where the arbitration will be held, if it's an arbitration, where the mediation will be held. And then, of course, you always say, and you don't have to say it, but you always say that the decision of the arbitrator will be final.
How many times do people come before arbitrators? From your even talking with your colleagues, and that clause is just one line: arbitration. In the event of a dispute, the arbitration, and they haven't defined all these things, and so they start to fight at that stage.
Very often, more often than I would care to
those
admit.
Clauses are usually, clause
Yes.
number 9J.
Yes.
Yeah, you
yes.
don't really look over
arbitration.
it. Yeah.
Yes. Yes.
And then the laws of Kenya. Bas.
But also, it may be precisely that, but the opportunity to vent seems to be greater in an arbitration than if you're in a court of law.
Yeah.
Because it's you, your protagonist, so whoever the other individual is, and the arbitrator. As opposed to a court of law where the lawyers take center stage. You are the audience. You sit and you wait to be represented. Here you are actually allowed to actually say your piece. And by the time you're going to any sort of mediation arbitration, you already disagreed. So you will vent.
Yeah.
And you will be right. Before you're now told, actually, there's...
No, you're not.
You maybe, but the other person is also right.
Looking at just a simple agreement here. All claims and disputes whatsoever arising under this agreement shall be referred first to mediation, failure to which parties shall be at liberty to seek recourse from the courts in Kenya. And it sounds
Okay,
very
so-
good, right?
No, because at what point do you decide the mediation has failed,
Has
and how
failed.
long do we wait before we then go to arbitration?
And does mediation mean arbitration?
And this, you know, we
That's-
have to start to understand these
Yes.
concepts and distinguish them from each other. Yes.
I think a lot of information. In fact, you ought to come back and now start taking us through each of these.
Yes.
When you are going for mediation, this is what you get. When you're going for arbitration, this is what you shall
When
get.
you're going for conciliation,
Conciliation, this is what you
We
get.
can even do a mock mediation.
Jackie, you'll come back.
Happy to do that.